SMS Edwin Tong.
Mr. Speaker, I thank the members who have spoken and for their full support of the bill. I also appreciate IPSA's input through Mr. Louis Ng, and I thank them for their contributions as well. Now, members have raised several points for clarification, and I would break them down into four main areas. They are firstly the scope of the bill, secondly the border enforcement process and how it compares with other jurisdictions, third, customs powers to request and provide information, request for information or documents, and finally the timeline for implementing the bill. I will address each of them in turn. In relation to the scope of the bill, Associate Professor Fatima Latif and Mr. Chris D'Souza inquired specifically about goods in transit. Goods in transit are by definition here for a short period of time. This makes any border enforcement action challenging. In addition, enforcement actions have to be balanced against the need to maintain our port efficiency. So generally, for goods in transit, customs officers do not detain the goods. However, customs officers will still perform the usual checks, and when they detect or suspect IP infringing goods, they will convey the information to their counterparts in the destination country. This then allows for effective enforcement to be undertaken in the destination country. However, as part of our existing international obligations, for suspected copyright infringing copies or counterfeit trademark goods in transit, which are consigned to a local party, customs officers have the power to initiate ex officio action to detain such goods, because there's a local consignee. Therefore, to address Mr. D'Souza's question, there are no similar international obligations, and we therefore make no distinction between goods in transit with a local consignee and goods in transit without a local consignee for geographical indications and registered designs. To aid customs, IP rights holders can provide information on shipments that are suspected to contain IP infringements. Mr. Ng also asked why the bill does not implement border enforcement measures for patents and ex officio action for registered designs as part of our obligations under Article 10.50 of the EUS FTA. Article 10.50 provides that the customs authorities shall adopt a range of approaches to identify shipments containing counterfeit trademark goods, pirated copyright goods, pirated design goods, and counterfeit geographical indication goods. There is no obligation under this article to implement border enforcement measures for patent infringing goods. In addition, it is also impracticable to do so because the detection of a suspected patent infringing good generally requires a higher level of specialized technical knowledge and expertise. Patents are therefore unlike copyright, trademark, registered designs, and geographical indications, where a visual inspection can usually be used to detect the IP infringement. Given the high level of specialization required to detect patent infringing goods, it is not feasible for customs officers to make such assessments. There are also no international obligations to take ex officio action in relation to registered designs. Unlike copyright or trademarks, it is difficult for our customs officers to identify whether particular goods infringe a registered design without any information. However, where a registered design owner files a formal request for seizure with specific information to identify a shipment with goods suspected of infringing registered designs, for example, when the shipment reached Singapore, our customs officers can assist in detecting and seizing such goods. And I hope that addresses Mr. Ng's queries. Mr. Ng also sought clarification on the rationale of the difference between he says, in the terminology and definition of counterfeit trademark goods between the EUS FTA definitions and Section 3.5 and 3.6 of the Trademarks Act. The definition in both provisions are substantially similar, and Mr. Ng may also know that the Trademarks Act was put into force in 2004, which is about 15 years ago, and we've kept that definition throughout. And the intention is to remain with that definition, but the level of obligation would not deviate substantially or materially from the EUS FTA definition. Associate Professor Fatima also asked whether our border enforcement regime covers parallel imports and goods in travelers' personal luggage. Parallel imports are not counterfeit goods. and are therefore not considered infringing under our IP laws. Therefore, in such a situation, they will not be detained. However, goods in travelers' personal luggage may be detained if they are suspected of infringing IP rights, and rights holders are prepared to take action. This has been the case even before these amendments apply. I will turn now to questions on the border enforcement processes. By definition, in enhancing the border enforcement provisions through this bill, it necessarily comes with enhanced powers and with some additional degree of intervention. With that, members have raised several queries on the processes involved where goods are seized. For example, the period of detention, whether they will be destroyed, how a defendant can show that the goods are genuine, and the remedies available where the goods were wrongly detained and found to be non-infringing. I think the majority of members raised questions around these few issues. Let me first be clear that customs are not allowed, without more, to destroy the goods which are seized. The various IP Acts all contain a framework to ensure that there is due process in the manner in which seized goods are dealt with, and I will now briefly describe that framework. Upon seizure, customs will notify the IP rights holders to verify the authenticity of the goods and commence civil actions for IP infringement against relevant parties within the period specified in the customs notice or any extended period as may be so notified. The status of the goods will then depend on whether an infringement action is commenced. Where an infringement action is commenced, the importer or exporter will be notified by the IP right holder if he is the defendant to the action, and have the opportunity to defend himself in court. Therefore, to address Professor Fatima's query, the court process will entail fact-finding and an evidence-based assessment in relation to the relevant copyright and IP provisions that are currently in place. Within 3 weeks of instituting an infringement action, IP rights holders will need to obtain a court order to prevent the release of the goods. So there's a 3-week timeline. Whether such a court order is granted or not will be decided by the court on a case-by-case basis, applying again the relevant IP provisions and laws. Where there is no such court order, the goods shall be released. Whether an individual is liable for IP infringement or not will be determined by the courts based on the facts of the particular case. Where the infringement action succeeds, the court may then, as part of the order, also order that the goods be destroyed. However, where the infringement action fails or is dismissed or is discontinued, the court may order that the IP right holder pay compensation to the defendant. The goods will then be returned to the importer or exporter as the case may be. In a situation where no infringement action is taken, any person aggrieved by the seizure may then apply to court for an order for compensation for any loss or damage suffered as a result of the seizure. I think Mr. D'Souza raised a question on that, and quite rightly so. The legal regime does protect the person in such a situation where no subsequent follow-up infringement action is then taken by the rights holder. The court may order compensation in such amount as the court thinks fit, and the goods will then be released to the importer or exporter. Mr. D'Souza asked how effective the mechanism has been in striking the balance between swift and effective action in deterring potential misuse of power. I think it's a question quite rightly asked. We don't track the request for compensation via civil actions under this mechanism, but the member will be assured to know that to date we have not received any complaints of IP rights holders abusing our border enforcement measures, given this mechanism and the other safeguards such as the need to provide a security deposit before the goods are seized. I now move on to the proposed expedited review process or indication that Mr. Ng and through the help of IPSA had raised. The proposal is a thoughtful one and one that we can consider further. But so far, the evidence we have suggests that IP rights holders are already capable themselves of making a quick assessment as to whether there's goods which have infringed the IP rights or not. In fact, it would be in their interest to do so, because if someone is peddling infringement or copyright breaches or breaches of copyright goods, then it will be in the rights holder's interest to move quickly and act swiftly. Where an expedited decision is required, parties can seek a summary judgment from court, and that's also a procedure they can avail themselves of, setting out their grounds. Nonetheless, we welcome IPSA to provide us with further details, as I said earlier, about this proposal, which we can then consider further. I'll now turn to deal with Professor Fatima's question on the training that is provided for our customs officers to identify counterfeit goods. Presently, customs already work with a number of brand owners to conduct training for officers from customs, the ICA, and a Singapore Police Force IP Rights Branch to look at, evaluate, and discern between genuine and counterfeit goods. Not always easy, but it's something that we work very closely with the brand owners. Upon detecting suspected counterfeit goods, our officers will also engage the IP rights holders to seek verification of the authenticity of the goods. Mr. D'Souza sought clarification on the difference between what the Director General of Customs, or DG, can prescribe and what the Minister can make rules on, particularly in relation to the notice to request for detention of suspected infringement goods. The clauses of the bill 12, 25, 35, 47, 53, 65 and 78, which I mentioned earlier, grant the Minister the power to make the necessary rules and regulations to provide for, amongst others, the manner in which the notices are to be given, and for the giving of information and evidence where the rules and regulations have a legislative effect. I know Mr. D'Souza drew our attention to the case in question, but in this case, the Customs DG is given the discretion to determine the specific form of notice. In other words, what exactly is the form it is to take? What are the documents or information that is required in that particular case, having had the powers already prescribed? These are administrative in nature and therefore need not be legislated by the Minister, as the case is generally for forms that are administered by public agencies. These are forms which will be readily accessible to the public on the website of Customs. I turn now to address Professor Fatima's query on whether our border enforcement laws and policy align with other jurisdictions. The short answer is generally yes, although inevitably differences will exist from one country to another, jurisdiction to another, depending on the local context and flavor. Singapore is also part of the TRIPS agreement, where all WTO countries are required to put in place border enforcement measures. These measures allow IP rights holders to request customs officers to seize suspected copyright and trademark infringing goods that are imported into the country. Many other established jurisdictions, such as the US, the EU, Australia, also provide further border protection mechanisms which extend to ex officio action and other types of IP infringements. Some of these jurisdictions also cover goods which are to be exported as well, as we are now seeking to do. Finally, let me move on to address members' queries relating to customs powers to request and provide information under the various IP Acts. Customs has been and will continue to handle sensitive commercial data obtained from traders. They are empowered to disclose such information as necessary to IP rights holders or use information internally for border enforcement purposes. These powers are given to Customs so as to facilitate the administration of justice and uphold our reputation of having a strong IP enforcement regime. Nonetheless, let me reassure traders at the outset that confidentiality of their data will be respected. Their data will remain confidential and will be used or provided only under limited circumstances in relation to the border enforcement matters as legislated. I wish now to address the members' queries on this matter in some greater detail. First, on the rationale for introducing these powers, and second, Customs' power to request information, and finally, Customs' power to provide information. The member, Mr. Azmun, asked for clarification on why the new powers for requesting and providing information are being implemented now and were not implemented before, and whether they are related to the EUS FTA. These new powers are not implemented pursuant to our EUS FTA obligations, but are intended to complement Customs' border enforcement duties. In the course of Customs' border enforcement work over the years, this was one area that was identified that needed some streamlining and which they felt would facilitate the work that they had with these adjunct and peripheral powers. The need to amend our legislation to fulfill the EUS FTA obligations now give us the opportunity to do so. And I would also add that the EUS FTA, whilst passed in 2014, was the subject of some challenge, and it was only in the course of last year, 2017, that the Court of Justice pronounced that the parties entering into it were competent to do so, and we were able to proceed with it, and hence we waited till this time to introduce our bill. Various members have asked about the scope of customs power to request information, the relevant safeguards, and also the privilege against self-incrimination in relation to the requested information. To be clear, customs will only be empowered to ask for any information that is relevant to border enforcement for the three defined purposes, and they are very clear. First, to provide IP rights holders with the name and contact details of any person connected with the import or export of the seized goods where necessary for instituting infringement actions. And we would regard that as quite the basic information before such actions can be instituted. Second, to facilitate enforcement against future shipment of goods. And third, for other statistical or research purposes relating to border enforcement. Various members have raised this point about information being requested. What does it entail? It would more likely than not, in most cases, include commercial invoices, the packing list, the bill of lading, airway bill, trans-shippers or shippers' details, and so on. In other words, information that would allow one to identify the goods, identify the source and the shipper, and perhaps its destination. These are all useful for identifying the relevant parties involved in the suspected IP infringement and the activities around that IP infringement. As for the type of information that can be requested for statistical or research purposes, this refers to information that can help customs build profiles of high-risk shipments and also enhance their capabilities to anticipate and target shipments which tend to be involved in shipping IP infringement goods. These will be details such as the names and contact details of the importer or exporter, description of the goods, and so on. In other words, to add to the customs database to ensure that in future, as these mechanisms become more and more sophisticated, that they can be better equipped to anticipate and also target the specific shippers in question. Mr. Ng and Mr. D'Souza also asked what is being done to ensure that customs are able to determine or discern the necessary information that should be requested for the three stated purposes. Customs will conduct relevant training for the officers. This is also a new area in terms of the enforcement, and so training will be done for the officers. They will seek to put in place a standard operating procedure as far as possible to make the guidance available to all the customs officers, to guide them in terms of seeking the relevant types of information, and to be more discerning and to be able to raise the right questions and focus their minds on the right issues and the right observations in relation to the three stated purposes. Mr. Ng also asked whether there is a limited period that customs will retain the information and for what period this will be. Customs will retain the information to the extent the purposes for collecting the information remains relevant and also generally in accordance with the government's record retention policy, depending on the platform on which the information is received. Next, I will address the concerns raised by Mr. Ng and Mr. Azmun on the safeguards relating to the information requested by customs. First, the person will be informed about the purpose for customs requests for his information at the point of request, and not when the information is shared with an IP right holder for the purposes of instituting infringement actions. Second, there are safeguards to ensure that the information will be kept confidential, particularly during research process. The information must be used strictly and only for the three purposes as explained earlier, and each request for the information and each proposed use of the information by customs officers for research or statistical purposes will be considered carefully. In addition, as provided in the bill, any person who discloses or uses the information for any other purpose shall be guilty of an offence and be liable on conviction to a fine not exceeding $6,000 or to imprisonment for a term not exceeding 12 months or to both. In addition, the information disclosed to the domestic public agencies will also be governed by the Official Secrets Act. Mr. D'Souza raised two questions regarding the privilege against self-incrimination provided in connection with the obligation to provide information as requested by customs. First, he asked whether a bare assertion that the information would expose a person to criminal liability will be sufficient to trigger the privilege. The short answer is yes, even if the information may turn out not to be self-incriminating ultimately. This would of course also be something which the court takes into account as may be appropriate, as it would do with any proposed adverse inferences to be drawn, as Mr. D'Souza raised. Second, he also sought clarification on the extent to which the privilege against self-incrimination is meant to operate. Where a person claims that his statement is self-incriminating and claims the privilege, the statement then cannot be admitted against him in criminal proceedings for any offences. The statement cannot be used at trial, whether as corroboration or for impeachment, as Mr. D'Souza knows. And the prosecution's case then has to be brought on other bits of evidence. However, where a person provides false information, that's quite a different situation. Such information may then be admissible against him in prosecution for an offence for providing false information. It would not be justifiable to shield or protect a person from being prosecuted for providing false information, as this would be entirely contrary to the interests of justice. Next, I will clarify the points that Mr. Ng raised about the scope of the customs power to provide information. There are several points. The first relates to the categories of persons whose name and contact details may be disclosed to IP rights holders. These are persons who I think I referred to earlier are likely to be the importer, the exporter, the consignee, or any other person involved in the shipping chain from which the IP infringing goods were seized. The second point that Mr. Ng raised concerns the time frame within which a person may request for information to institute an infringement action. There is no specific time frame prescribed in the Act itself, but for reasons I've outlined earlier, it will be in the interest of the rights holder to move expeditiously. And that's also because there is a stipulated timeline within which he must then institute the infringement action in relation to the seized goods. Therefore, he should seek, I think, would be expedient to seek the information within this timeline and not outside. And in this context, he has also got to do so after providing customs with a security deposit and supporting documents evidencing the IP rights. Finally, I wish to elaborate on the timeline for the implementation for the new border enforcement measures for copyright, trademarks, and registered designs as requested by Mr. Azmun. The enhanced border enforcement measures for copyright and trademarks will be effected once the EUS FTA enters into force or comes into force. As I explained earlier, it has not yet come into force. It will do so. We will have the measures coincide with that. The new border enforcement measures for registered designs will be effected within 3 years after the EUS FTA enters into force. And as I've explained at the outset, it gives time for businesses and people to adjust to this. As I mentioned earlier, sufficient notice will also be provided before the commencement of the relevant provisions. Finally, in conclusion, I wish to thank all members who have spoken and supported the bill. The bill represents our commitment to honour international obligations by strengthening our border enforcement processes, and also instills in us the upholding of IP rights, as Mr. D'Souza mentioned, critical not only to IP, but also to various aspects of business in Singapore. Mr. Speaker, I beg to move.
Question is that the bill be now read a second time. As many as are of the opinion say aye. Aye. To the contrary say no. I think the ayes have it. The ayes have it.
The Intellectual Property Border Enforcement Bill.
Committee stage, what day?
Now, sir, I beg to move that Parliament will immediately resolve itself into a committee on the bill.
The question is that Parliament will immediately resolve itself into a committee on the bill. As many as are of the opinion say aye. Aye. To the contrary say no. I think the ayes have it. The ayes have it. The question is that clauses 1 to 91 stand part of the bill. As many as are of the opinion say aye. Aye. To the contrary say no. I think the ayes have it. The ayes have it. Bill to be reported. Minister for Law.
Mr. Speaker, I beg to report that the bill has been considered in committee and agreed to without amendment.
Third reading, what day?
Now, sir, I beg to move that the bill be now read a third time.
The question is that the bill be now read a third time. As many as are of the opinion say aye. Aye. To the contrary say no. I think the ayes have it. The ayes have it.
The Intellectual Property Border Enforcement Bill.